Good afternoon, everyone. Good afternoon. Yeah, great MIT welcome. Good afternoon. Thank you. Thank you all for coming today. To those of you who joined us during our last Dialogues Across Differences event, welcome back. And for those of you who are joining us for the first time, thank you for signing up and for showing up. Your coming here today means you are joining fellow members of our MIT community to learn together and to participate in difficult and important conversations together. We want to make space for each of you to be here fully and to engage thoughtfully with our speaker and with each other without worrying about social media. So we ask that you refrain from taking photos or recording during our time together today. We have a team in place to record today's events. The cameras in the back are focused exclusively on us in the front, not on you. When you checked in, you all received a bright green paper with 2 QR codes. One of the QR codes is for you to submit a question. The other QR code will take you to the text stream of this program, should you decide that you want to follow along on your mobile device. If you need assistance in submitting a question, ask a member of the events team. All questions today will be anonymous. You do not need to include your name to submit a question. Professor Erwin Chemerinsky will answer as many questions as he can. That said, he likely won't have much time during the Q&A question to answer every question that he gets, and then he needs to leave right after the Q&A session to get to the airport for a flight back to the West Coast. That said, we still want you to join us for reception immediately following this program, which it will be next door, in order to continue with our conversation. I want to encourage you to keep this dialogue going, to keep it going way beyond today's events, and to bring fellow MIT community members into our conversations. Now I'll turn the floor over to President Sally Kornbluth. Welcome, Sally.
Thanks very much, Melissa, for the introduction and for your ongoing leadership of the Standing Together Against Hate. And like Melissa, I'm very grateful to all of you who've made the time to join us today. I think it's important. Now, if MIT were a law school or MIT had a law school, today's speaker would require absolutely no introduction. He helped found the UC Irvine School of Law as its first dean, and since 2017 has led the law school at UC Berkeley. The 16 books he's written include the leading text on constitutional law, and in 2017, he was named by National Jurist as the most influential person in legal education. A gifted appellate lawyer, he argues regularly before the U.S. Supreme Court. For their clarity and masterful synthesis, his updates on current Supreme Court cases have been described as legendary, and he is far and away the most cited scholar of U.S. constitutional law, and it goes on and on like that. However, again, as you know, MIT is not a law school, does not have a law school. So how did we prevail on Dean Erwin Chemerinsky to fly across the country to join us today? Because on top of everything, he is an expert on issues of freedom of expression and university life. A quick personal reflection, back when I was a professor of cancer biology at Duke, I confess that I didn't think about freedom of expression very often. But when I became provost, that changed. As we were grappling with a particular situation I don't need to go into, I needed to know much more about both the history and the practical questions around freedom of speech on campus. So you can imagine how grateful I was to find that, along with his colleague, Howard Gilman, Erwin Chemerinsky already wrote the book. And this is not his book tour, but I will say this is a great book on, with a convenient title, in case you forget it later, Free Speech on Campus. More recently, last October, he wrote a piece in the Los Angeles Times describing his shock at the startling rise of anti-Semitism on his own campus and across the country. So today, as our community confronts the challenges of building a culture of freedom of expression while sustaining a welcome community for all, we could not ask for a better guide than Erwin Chemerinsky. This afternoon's program consists of Dean Chemerinsky's talk, Campus Freedom of Expression, Antisemitism, and the Current Controversies, followed by a fireside chat led by Professor Ed Schappa. Many of you know Ed. He is the John E. Burchard Professor of Humanities at MIT. He served for 6 years as head of comparative media studies and writing. His research ranges from classical rhetoric to communications to popular culture. Ed has written a dozen books and been published in 6 disciplines: psychology, philosophy, English, classics, communication, and law. And he's also an expert on political consequences of definitions, in particular how contested terms from wetlands to personhood come to mean what they mean and why those definitions matter. Because Ed was a member of the intrepid faculty working group that developed the MIT Statement on Freedom of Expression and Academic Freedom, he brings special credentials to this fireside chat. So, Ed, thank you for your leadership and insight on this perpetually complicated topic. So for now, please join me in welcoming Dean Erwin Chemerinsky to the stage.
President Kornbluth, thank you so much for that incredibly kind introduction. It's really an honor and a great privilege to be with you. Issues of free speech on campus have been around as long as there have been campuses. But the issues with regard to freedom of expression in college universities have become much more salient since October 7th. There are protests and demonstrations across the country at universities that others decry as hateful. There are calls to suppress them. As you know, on December 5th, 3 university presidents, including yours, were called to testify before a House committee. 2 of those individuals are no longer presidents of their university. I thought what I would do this afternoon is outline basic principles of free speech on campus and focus particularly, as I was asked to, with regard to anti-Semitism. I would outline 5 principles for you. The first is that the First Amendment applies only to public college universities, but private universities often choose to be bound by the same principles that the Constitution imposes on the government. One of the most basic principles of constitutional law is that the protections of liberty, of equal protection, apply only to the government. The Constitution doesn't apply to private institutions. An easy illustration: it's a true story of a conversation I had with my oldest 2 children over 30 years ago. We were in a grocery store. Diet Coke was giving away free baseball cards at the time, and 3 were pictured on the outside of the package. As we went up and down the aisles of the grocery store, my 2 sons, then 9 and 6, were fighting, as they often did at that age. They were arguing about who was going to get the extra baseball card. Finally, I said, "Be quiet. I don't want to hear anything else about baseball cards till we leave the grocery store." My then 9-year-old turned to me and said, "You can't tell me to be quiet. I've got freedom of speech." I was ready for him. I said, "Freedom of speech means that the government can't tell you to be quiet. I'm not the government, so I can." To which he, without missing a beat, turned to me and said, "Well, you're like the government to me, so you shouldn't be able to tell me to be quiet." It's a true story. It's when I first knew that someday he was going to go to law school, and right now he's running for district attorney of Los Angeles County. But while private college universities like MIT don't have to comply with the First Amendment, they can choose to be bound by principles of freedom of expression. In fact, in some states, they have no choice. In California, there's a law called the Leonard Act that says that private college universities cannot punish speech that public ones cannot punish because of the First Amendment. Every college university has a faculty handbook and a student handbook. These have been construed by courts as contracts with the faculty and students respectively. Often these provide protection for academic freedom, for freedom of speech. Many campuses have written policies. I think MIT has one of the very best, and I've said this in front of other audiences as well, the principles of freedom of expression and academic freedom that were recently adopted. I believe that these are binding on the campus, even though the campus didn't have to pledge such fidelity to principles of freedom of expression. The second point that I want to make is that all ideas and views can be expressed, period. This is the core of the First Amendment. I believe it's the core of the MIT policy as well. The United States Supreme Court repeatedly has said that the central teaching and meaning of the First Amendment is that the government never can suppress speech or punish expression based on the views that are being conveyed. Doesn't matter how offensive they are. To illustrate, there was a Supreme Court case about a decade ago, Snyder versus Phelps, involved a small church out of Topeka, Kansas, the Westboro Baptist Church. They made it a practice of going to funerals of those who had died in military service and using them to express a very vile anti-gay, anti-lesbian message. Matthew Snyder was a Marine who died in military service in Iraq. The members of the Westboro Baptist Church went to his funeral in Maryland. Before it began, they asked the police where they could lawfully stand. The officer pointed an area about 1,000 feet away from the ceremony to be held. Before the ceremony, they chanted and sang. During the ceremony, they were silent, but held up signs. That night, Matthew's father, Albert Snyder, was watching the news, and he could read the signs. He was deeply offended. He sued the members of the Westboro Baptist Church for intentional infliction of emotional distress and invasion of privacy. A jury awarded him $10 million, but the United States Supreme Court, in an 8-1 decision, reversed. Chief Justice Roberts wrote for the court, and he said, what I've articulated for you this afternoon, under the First Amendment, all ideas and views can be expressed, even deeply offensive ones. The third point that I make for you this afternoon is that freedom of speech is not absolute. We're all familiar with the words of the late Justice Oliver Wendell Holmes, that there's no right to falsely shout fire in a crowded theater. The Supreme Court has said that there are categories of speech that are unprotected by the First Amendment. That is, the government can prohibit and punish such expression. Child pornography is a category of speech unprotected by the First Amendment. False and deceptive advertising is a category of speech unprotected by the First Amendment. For purposes of college universities, 3 categories of unprotected speech are particularly important. One is incitement of illegal activity. For more than a century, the Supreme Court has said that speech that incites others to commit acts of illegality, not protected by the First Amendment. But it's very important here, and as for all these categories, to draw a distinction between the colloquial use of the word and the legal test. The Supreme Court, in Brandenburg versus Ohio in 1969, articulated the test for incitement. And it's a very difficult test to meet. It's quite speech protective. In order to be incitement, unprotected by the First Amendment, there has to be a likelihood of imminent illegal activity, and the speech has to be directed at causing imminent illegal activity. Imagine somebody says something on campus that's anti-Semitic and deeply offensive. And it's unlikely to meet the test for incitement unless it can be shown there's a likelihood of imminent illegal activity, and the speech was directed at causing imminent illegal activity. A second category of speech that's unprotected is true threats. That's a phrase that comes from the United States Supreme Court. It wasn't until June of 2023 that the Supreme Court gave us a definition of true threats. The Supreme Court said, in order to punish somebody or hold them liable for a true threat, you have to show that they were reckless and in disregard that their speech would be perceived as a threat of violence. Let me give you an example. Imagine a student, and so I was asked to focus on anti-Semitism, we can make it a Jewish student, is walking across campus. And an angry group surrounds that student and yells anti-Semitic slurs. Even if no blow is struck, those who yelled at that student could be punished for a true threat. A reasonable person under those circumstances would fear violence. The speakers were at least reckless, if not intentional, in causing that apprehension. So that's not speech protected by the First Amendment. A third category of speech that's not protected is that which constitutes harassment. There's a good deal of law here in the employment context. Many courts have applied it to the educational context as well. Take the easiest example. Imagine an employer says to an employee, "Sleep with me or you're fired," and the employee sues for harassment. The employer has no defense, just saying, "It was only speech that I was engaged in." Likewise, courts have found that there can be, on the basis of speech, a hostile environment that rises to the level of harassment. In the employment context, courts have said that the speech has to be sufficiently severe and pervasive to materially interfere with employment opportunities based on race, sex, religion, sexual orientation. Courts have now applied this to the educational environment. In order to be harassment, the speech has to be sufficiently severe and pervasive to materially interfere with educational opportunities based on race, sex, religion, sexual orientation. A single incident might arise to the level of harassment. Again, since I'm focusing on anti-Semitism, imagine a Jewish student who lives in a dormitory, and imagine a swastika is drawn on that student's door. I think that would be harassment under the law. To give you an example of this in the college context, I want to talk about a case that I argued in the Federal Court of Appeals a few years ago. It involves a public university in Virginia, Mary Washington University. The case is called Feminist Majority Foundation versus Hurley. There's a debate on campus at Mary Washington University as to whether to allow Greek life. 3 women wrote an op-ed in which they argued that the campus should not allow fraternities. They said that when there are fraternities on campus, there's more sexual violence against women. They were then targeted over the then social media platform Yik Yak. Over 600 messages were sent to and about them, many quite vile, some threatening rape and murder. They went to the campus and asked the campus to take some action. The campus said it was anonymous speech over social media. There was nothing the campus could do. In fact, the campus even posted on its public website, when it's anonymous speech over social media, the campus has no responsibility. The Feminist Majority Foundation filed a lawsuit on behalf of the women students. The federal trial court ruled against them, saying this was anonymous speech over social media protected by the First Amendment. I represented the women and argued their case in the United States Court of Appeals for the Fourth Circuit, and the women prevailed. The Court of Appeals said that here the speech was so severe and pervasive, it would materially interfere with their educational opportunities based on sex, and thus violated Title IX. So these are the 3 categories of speech that are unprotected, that are most important for college universities: incitement, true threats, harassment. Of course, there'll be difficult line-drawing enterprises with regard to each. But you'll notice what I didn't mention as a category of unprotected speech, and that's hate speech. That's because the Supreme Court has been clear on many occasions that hate speech is protected by the First Amendment. The most frequently asked question I receive, and I got it today in one of the wonderful sessions I had, is where is the line between free speech and hate speech? And my response is that's a false dichotomy, because hate speech is generally protected by the First Amendment. For example, there was a Supreme Court case in 1992, RAV versus City of St. Paul. St. Paul, Minnesota, adopted an ordinance that prohibited burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. Burning a cross, painting a swastika are ugly symbols of hate. But the Supreme Court unanimously declared that ordinance unconstitutional, making clear that hate speech is safeguarded by the First Amendment. In the early 1990s, over 360 college universities adopted hate speech codes. Every one to be challenged in court, without exception, was declared unconstitutional. Why? After all, almost every European country has a law prohibiting hate speech. Why in the United States do we allow hate speech? There's no doubt that hate speech causes great harms. In part, I think it's because of the difficulty of defining what's hate speech in a manner that's not unduly vague or overbroad. The Supreme Court has been clear that any law or regulation of speech has to be clear about what's prohibited and what's allowed. It can't regulate more speech than is necessary under the Constitution. Most of the campus codes prohibiting hate speech copied the language from European laws. They prohibited speech that, quote, stigmatized or demeaned on the basis of race, sex, religion, sexual orientation. But ask yourself, what does it mean to stigmatize or demean? The plaintiff in one of the leading lawsuits, it's the University of Michigan, argued that he was a sociobiology graduate student. He said his research was whether there inherent biological difference between men and women. And he said he didn't know whether his research could be found to stigmatize or demean. The federal court found the University of Michigan hate speech code unconstitutionally vague and overbroad. I think there's also hesitation about allowing hate speech laws because of the way in which they've been used. History shows that they're much more likely to be used against the very people they're meant to protect. I mentioned the University of Michigan hate speech code. Between the time it was adopted and when it was struck down by the federal district court, every enforcement action under it, without exception, was brought against a person of color. When England adopted its first hate speech law, the initial prosecution under it was against a Zionist group, with a prosecutor saying Zionism is a form of racism. You'd be surprised if I tell you who's been the most frequently prosecuted individual under France's hate speech law. The actress Brigitte Bardot. She's an animal rights activist, and she's against using animals in religious rituals, and has repeatedly been prosecuted under the law. But most of all, I think in the United States, hate speech is deemed to be protected by the First Amendment because it expresses an idea. It's a vile idea, but it's one protected. So to return to anti-Semitism, there is a First Amendment right to express anti-Semitic ideas. There is a First Amendment right to say terrible things about Jews or any other group. The First Amendment provides protection for this, even though we'd all wish such hate speech never existed. Well, this then brings me to the fourth part of my remarks, and that's that there can be time, place, manner restrictions with regard to speech, so long as they're content neutral, so long as they serve an important purpose, and so long as they leave adequate alternative places for communication. Even if there's a right to use government property for speech, it doesn't mean that it has to be available at all times and for all manner of speech. Campuses, for example, can have rules preventing demonstrations in or near classroom buildings while classes are in session. Campus can have rules that prohibit sound amplification equipment from being used when classes are in session. Campus can have rules that restrict speech in or near dormitories, evening and nighttime. All of that is time, place, manner restrictions. I've done some reading about Lobby 7 here at MIT. And again, MIT is a private school. It doesn't have to comply with the First Amendment. But if it were a public school, it could certainly have rules limiting it or other places for speech so as to make sure that they're available for pedestrian traffic and they don't interfere with the operation of the campus. Campuses certainly can have requirements that individuals, if they're going to have protests, get a permit or permission 3 days in advance, so long as it is a time, place, manner restriction, so long as it's content neutral, so long as it serves important purpose, so long as there are adequate alternative places for communication. Rather than talk about MIT, where I know very little, let me talk about my campus, the University of California at Berkeley. In the fall of 2017, a campus group, conservative group called the Patriots, decided they were going to have Free Speech Week, invited a number of very controversial speakers, Milo Yiannopoulos, Ben Shapiro, Ann Coulter, Charles Murray. And our Chancellor, Carol Christ, was very kind and said to me, do you have any suggestions about what we should do? The prior January, there had been a major dispute on the campus when Milo Yiannopoulos had come to speak. I said, my suggestion was, have the most controversial speakers have to speak in an auditorium, don't give them permission to speak in the open areas of the campus. That if they're in an auditorium, you can, if necessary, have metal detectors. You can check IDs. Campus security can be able to protect the premises. But if it's out in the open, there's no way to control it and no way to prevent what had happened like the prior January. The chancellor decided to do this and said that one of the speakers would have to speak at 7 o'clock in the largest auditorium on campus, Zellerbach Hall. He and his supporters objected and sued the university. But the courts ruled in favor of the university. The court said it was a time, place, and manner restriction. It was content neutral. They weren't targeting speakers on the basis of viewpoint. That it served an important purpose of security, and it certainly gave an adequate alternative place to speak, 7 p.m. in the largest auditorium on campus. One of the hardest unresolved issues with regard to this is how much does a campus have to pay for security before it can say, we can't afford the safety and we won't allow the speaker. In the context of the Free Speech Week I mentioned in the fall of 2017, Berkeley spent $4.5 million for security. What if it wasn't Free Speech Week? What if it was Free Speech Semester? What if it wasn't $4.5 million, but $45 million? Surely there has to be a place where the campus can say, we can't afford the cost of security. Every dollar is coming away from some other educational purpose, so we're not going to allow the speaker. But no court has yet defined where that line is drawn. Fifth and finally, I want to talk about some of the difficult issues that are arising now on campuses across the country. Let me mention a few of these that are occurring. One involves Title VI of the 1964 Civil Rights Act. Title VI says that recipients of federal funds cannot discriminate on the basis of race. The Supreme Court has interpreted this to also include a prohibition of discrimination based on ethnicity or national origin. You might have heard that this past fall, the Assistant Secretary of Education for Civil Rights, Catherine Lehman, said that 6 major universities are being investigated for not having adequately dealt with anti-Semitism. What about the tension between free speech on the one hand and Title VI obligations on the other? If a public university punishes the anti-Semitic speech, it would seem to violate the First Amendment. But if it doesn't punish the speech, is it violating Title VI? My answer to this goes to the legal standard under Title VI, and the same under Title IX with regard to sex discrimination. A campus cannot be deliberately indifferent to harassment on the basis of race or sex. That doesn't mean that the campus can or should punish the speech, but it means that the campus can't be silent. It can't refrain to take any action. Again, I'll go back to the case that I argued in the Fourth Circuit, Feminist Majority Foundation versus Hurley. It's exactly what the court said. The court didn't say that Mary Washington University needed to find out who were the students over Yik Yak and punish them. But it did say that the campus had an obligation to take some action and could not be deliberately indifferent. There are many things that campus can do. Campus officials can use their bully pulpit and speak out against the harassment. Campuses can provide protection for students where appropriate. Certainly in instances where students are threatened with rape and murder, that would be a necessary action. Campuses can create educational programs. Campuses can provide counseling and mental health services, and I can go on with the list. But I think the solution when it comes to speech that might be regarded as harassment under Title VI isn't to immediately respond by suppression, but to take action. There's a good deal of debate over whether slogans on campus, like from the river to the sea, Palestine will be free, or we don't want no two-state, we want 48, should be regarded as anti-Semitic. I don't think any campus is going to resolve the definition of anti-Semitism. But if these are seen as creating a hostile environment for Jewish students, campuses certainly can and should take some action. Again, that doesn't mean suppressing or punishing the speech. A second issue that often comes up on campuses now is what's sometimes referred to with the euphemism deplatforming. And the reason I say euphemism, it's just another word for disrupting the speaker. You might have heard a couple of years ago of this happening at some major law schools. There was an incident at Yale Law School where a lawyer from Alliance Defending Freedom came and students shouted so she couldn't be heard. There was an incident at Hastings Law School in San Francisco where Ilya Shapiro came and the students protested so he couldn't be heard. There was another incident last year at Stanford Law School where Federal Court of Appeals Judge Kyle Duncan came and the students yelled and protested in a way that he couldn't be heard. To be clear, there is no First Amendment right to use speech to disrupt the speech of others. Students certainly can protest in a non-disruptive way. They can bring in their own speaker, but there isn't a right to use one's speech to silence somebody else. Otherwise, it would be a heckler's veto. Otherwise, the only speech we'd ever hear is that which no one cares enough to try to silence. Again, to give an example I remember well and had involvement with, a little over a decade ago, the Israeli ambassador Michael Oren was coming to speak on the campus of the University of California, Irvine. As soon as he began to speak, a student stood up from the back of the room and shouted so he couldn't be heard. Security escorted that student away. Then another student stood up and shouted. That student was escorted away. After 4 students did this, the chancellor of UCI, Michael Drake, stood up and said, please let Ambassador Oren be heard. There'll then be time for questions and responses. 7 additional students, one after another, stood up and chanted, yelled, so Michael Oren couldn't be heard. Till finally, as a group, they all got up and walked out. Ambassador Oren finished. Could those students be disciplined for what they did? Absolutely. There is no First Amendment right to use speech to silence others. A third issue that's often coming up now is with regard to social media. I think that the hardest issues with regard to the First Amendment and freedom of expression are going to involve the internet and social media. The internet and social media are the most important developments for speech since the printing press. They've democratized the ability to reach a mass audience. It used to be in order to reach a large number of people, you need to be rich enough to get a broadcast license on a newspaper. Now, any of us with a smartphone, or even just access to a modem in a library, can reach a large audience. There's tremendous benefit to that in terms of freedom of speech. But there's also a real cost. The speech can invade privacy, it can defame, it can be hateful, it can be tremendously ugly. And the question is coming up now as to when can schools punish speech that's off campus over social media? There's one Supreme Court case about this from just a few years ago. It involved a high school student, but I think the principle applies to college and universities as well. It was a case called Mahoney Area School District versus BL. Brandy Levy was a rising sophomore at a public high school in Pennsylvania. She tried out for the varsity cheer team. She was upset when she learned she was again assigned to the junior varsity. She was furious when she found out a freshman made the varsity ahead of her. She went on a social media platform on a Saturday morning, and she did a rant. She raised both middle fingers. She repeatedly used the profanity that starts with the letter F. The next day, she recorded another rant, but without the profanities. On Monday, the cheer coach was able to view the video. He deemed this to be conduct unbecoming a cheerleader and suspended her for the team for the year. He said, try it again the next year. No other punishment was imposed on her by the school. But Brandy and her parents sued, and they won. They won in the federal district court, they won in the Federal Court of Appeals, and they won in the Supreme Court in an 8-1 decision. Justice Stephen Breyer wrote for the court, and he talked about the importance of protecting speech by students over social media. He said, we don't want schools to be able to punish students what they do 24 hours a day, 7 days a week. He said, how are we going to be able to teach students the importance of free speech if we're punishing their expression? But he was also clear that it's not an absolute right. He said, if the speech is bullying, harassing, cheating, then it can be punished. If it can be proven that the speech is actually disruptive of school activities, then even though it's out of school on the weekend over social media, it can be punished. And there are now a number of lower court cases applying the same principle to colleges and universities. So these, I think, are the basic principles that guide us in talking about free speech on campus, including with regard to anti-Semitic speech. I realize that I may not have persuaded you. There are many who disagree, who believe that there should be much less protection of speech, including anti-Semitic speech, on campus. What I always say to my students, though, is I believe that the only way that my speech will be safe tomorrow is to protect the speech that I don't like today. We don't need principles of freedom of expression, the First Amendment, to protect the speech we like. We'd let that happen anyway. The only reason we need freedom of speech is to make sure that the speech we don't like gets safeguarded. Ultimately, my view with regard to the First Amendment and freedom of expression is based on a tremendous distrust of government and of those in power, including college administrators. My view with regard to the First Amendment and freedom of expression is based on the idea of faith that we are better off letting all ideas and views be expressed than we are giving to the government or to college administrators the power to say, these are the ideas that are okay, and these are the ideas that aren't allowed. It's a faith. It's a faith that I have at least most of the time. Thank you so much.